Welcome to the University of Minnesota's webinar series, When Law, Ethics, and Medicine Collide. I'm Susan Wolf, Regents Professor of Law and Medicine and Faculty Chair of the university's Consortium on Law and Values in Health, Environment, and the Life Sciences, the sponsor for today's series. We have three tremendous experts with us today to discuss a critical issue: physician duties when law restricts reproductive care. For nearly 50 years, Roe v. Wade protected a pregnant person's right to terminate a pregnancy in the United States. But after the Supreme Court's 2022 decision in Dobbs versus Jackson Women's Health Organization overturning Roe v. Wade, many states have adopted laws restricting abortion and reproductive care, in some cases severely. The Guttmacher Institute, which is among those tracking state laws, so you can Google that and look it up online, reports that at this point, 13 states have banned abortion throughout pregnancy, and another 28 states have banned abortion based on the duration of gestation, some as early as 6 weeks of pregnancy, all with limited exceptions that vary by state. And states may threaten physicians by law with criminal penalties, including imprisonment. In some cases, for example, Texas, very long prison terms, disciplinary penalties, including loss of licensure, and civil penalties. With this major shift in the legal landscape, many physicians now face a conflict between their professional obligations to provide timely care for patients and the restrictions in state law. And we've all seen cases reported in the national news of women denied timely care and then suffering severe and in some cases fatal consequences. So we have convened three experts today to analyze this conflict between law, ethics, and clinical care, and hopefully offer guidance. Our speakers bring multiple perspectives and will address the full range of medical, legal, and ethical issues. Our speakers are Dr. Judette Louis, who is the James M. Ingram Professor and Chair of the Department of Obstetrics and Gynecology at the University of Southern Florida, Morsani College of Medicine, as well as Chief of Tampa General Hospital Women's Institute in Florida. Secondly, we have Professor Dov Fox, who is the Herzog Research Professor of Law and Director of the Center for Health Law, Policy, and Bioethics at the University of San Diego School of Law in California, and Dr. Ann Drapkin-Lyerly, who is Professor of Social Medicine and a Research Professor in the Department of Obstetrics and Gynecology at the University of North Carolina, Chapel Hill. All three of our speakers have published on these issues, and if you go to the consortium webpage for this webinar, you'll see a link to related resources, including some of their publications and much more. So I very much encourage you to use and share those resources to dig deeper into the issues. I should also note that although we have these wonderful experts today on law and medicine, our discussion does not constitute medical or legal advice. For that, you need to consult your own clinician or your own attorney. So the order of march is that each panelist is going to present for about 15 minutes, and then we're going to all convene in gallery view and then open it up for discussion and your questions. And you can use the QA function in Zoom. Already that's live, so please fire away. And you can also upvote a submitted question that you particularly want to see answered using that thumbs up icon. If anybody would like to post or tweet on X, please use the hashtag physician duties. Run it all together, physician duties. And you can also look for the consortium's tweets during this event at UMN Consortium. So just a couple of other housekeeping things before we get going. If you have technical difficulties during the webinar, please email consortm@umn.edu, consortm@umn.edu, and our staff is sitting by and will be very happy to help. I would like to thank our tremendous consortium staff and University Video Services for managing all the logistics of today's webinar. We are recording. The webinar is being recorded, and that raw recording will be posted on our YouTube channel and consortium website immediately after the event. A slightly edited version, just to clean up if there are any snafus, will be posted several days later. And again, please use, share, teaching in any way you see fit. All registrants will receive an evaluation to complete after the event today, and we'd love it if you take just a few minutes to give us feedback. We read every single one, so please share your thoughts. And finally, today's speakers and I as moderator have no relevant disclosures. Okay. So with that, let me introduce our first speaker, Dr. Judette Louis. She is the James M. Ingram Professor and Chair of the Department of OBGYN at the University of South Florida Morsani College of Medicine, where she serves as Division Chief and Fellowship Director of Maternal Fetal Medicine. She also holds a faculty position in the university's College of Public Health and is chief of the Tampa General Hospital Women's Institute. She is past president of the Society for Maternal Fetal Medicine, which represents over 6,000 clinicians and researchers in this country with experience in high-risk pregnancy. She's authored more than 90 scientific articles and book chapters on reproductive medicine, including on maternal morbidity and mortality, sleep and pregnancy, and health disparities in maternal fetal medicine. Welcome, Dr. Louis.
Thank you so much. Thank you for the opportunity to participate in this discussion about a topic that obviously affects my life daily because of where I work and the work that I choose to do, but certainly the patients who are in restrictive areas. You know, as we speak right now, if I look out my window, the thing that I see prominently is a banner. And it's a banner that is posted on a church that I can see from my window all the way here. And that banner is advocating that people vote no on the ballot measure that would protect abortion rights. It highlights the challenges that we have as physicians. You know, when we chose to do this job, we wanted to take care of patients. We learn about the medical management. We know the importance of early diagnosis and the appropriate treatment, right? Getting the first treatment, be the right treatment, improves outcomes. But yet what's happening under these restrictions is that there is a whole line of treatment that is being kept from us and from the patients. And without doubt, that involves some ethical principles, because now the patient does not have autonomy. They do not have a complete say in the treatments that they choose for their given condition. And certainly for those who are, who believe in providing the patients access to all of the care that they do have a right to and should have, they are now having a restriction in the access that they have. And when we talk about this situation, understand that for sure there are short-term implications and there's long-term implications. And when we talk about the access, that they are not getting care now. But what we do know that is happening is that as we get restrictive states, more and more of them, over time, what we're seeing is that there's a decrease in physicians who want to come practice in those areas because of the concerns over these laws and the implications for them, but particularly for trainees. We already have a shortage of healthcare professionals, particularly in these restrictive states. They're also the states that have the highest maternal morbidity and mortality. And so we're facing further shortages if trainees don't want to come here. Also, as we restrict these procedures, fewer and fewer people are doing them. So that even in states where they say, well, we have an exception for maternal life, you are decreasing the number of individuals who are skilled at doing these procedures that are not common. So therefore, you need the few numbers that you get to keep up your skills. So we are restricting access currently, but also in the future. And those are important considerations. The conversation around these restrictions also have been a little bit problematic. And what you see is that there's a lot of conversation around what we call the blameless abortions, right? So, maternal life, which is very important to me, obviously, as someone who practices high-risk obstetrics. But I think it also takes away from those who argue that abortion is healthcare, period, and that we shouldn't lose sight of that. And when you talk about other treatments, you don't see other treatments being legally restricted. You don't see limitations on chemotherapy. You don't see limitations on diabetes medications. And so if this is healthcare, if this procedure is part of healthcare, why is this the one that's being restricted? And so it goes back for all of us who are in healthcare, goes back to a lot of the ethical principles and really puts us in a situation where so many feel that they are forced to choose between the patient and themselves, right? Because if something is illegal, but yet it is the right treatment, it's an impossible position to be in, to feel like you're not providing the patient with the treatment that they need because you are at risk. There are other arguments that we receive that, we will receive sometimes emails from certain entities that say to us, well, the law says there is a permission, so to speak, for or an allowance for cases in which the mom's life is in danger or in which there's, fetal considerations. The challenge in those in real life, right? It sounds good on paper, but in real life is the way that the laws are written. It's not clear to anybody what meets criteria and what doesn't meet criteria. For instance, if you say there's an exception for life-threatening conditions for the mother, there's been challenges in figuring out, well, what exactly does that mean? And who will consider something, a condition, life-threatening? Do you mean immediately life-threatening, as in, I will probably die in the next day, or life-threatening as in this condition exacerbates, pregnancy exacerbates this condition, and so it will shorten my lifespan? And what criteria do you need to prove that you agree that it is life-threatening? And will the person who is looking at this case and prosecuting this case, will they agree with that? So these are the things that boots on the ground, the considerations, the questions that we are having and the concerns we are having, and that none of that is clear. And so if none of it is clear, then what ends up happening is that it's left to the individual and to the individual systems as to how they interpret these laws. And so then you have really a difference in how it's implemented and how it's executed. And what determines how it's executed includes who your leadership is and also where they get their funding sources, right? So very commonly, state by state, city by city, academic centers have the most acute cases and the most complex cases, but they are also more likely to have state funding. And so they are more likely to be vulnerable. And so how does that play into what the system decides in terms of how they interpret the laws? That's a consideration that many of us are living under. And so you have scenarios where we're limited not by our individual interpretation of the law, but how our lawyers interpret it and how our health systems interpret it, and also how our institutions interpret it. But I wanted to take some time to talk about some of the stories that patients have shared about their own experience, and certainly stories that I am seeing as someone who practices high-risk obstetrics. Again, as I mentioned, systems differ in how they interpret it. And so you take one condition, preterm premature rupture of membranes, if it happens before a viable stage, so before the baby can survive outside of the uterus. So let's say rupture of membranes at 18 weeks. We know that there is clear data that increases the risk of bad outcomes that include things like an infection in the uterus of the mother, hemorrhaging, more likely that the mother will lose their uterus, and then the more severe versions of the infection where they can get sepsis, end up in the intensive care unit, and in the worst case scenario, die from it. And it's happening the rupture is happening at a gestational age where the baby cannot survive. So to continue that pregnancy without intervention puts the mother at risk. So intervening, so terminating the pregnancy is one of the treatment options, and it should be a treatment option that the patient is offered. But under these restrictions, most places are not offering them until they see what they call irrefutable signs that the mother's life is in danger. So they're waiting to see signs of infection. And some places will wait until they see multiple criteria. So they want to see the fever and the elevated white count. And while some people may think, well, that's reasonable to see the criteria, the problem with that is the more signs of infection that you show, the more likely it is that disease will progress, and that for a subset of the patients, you get to a point where you cannot reverse, that your treatments can be ineffective, and you end up with severe outcomes like a hysterectomy that then takes away the patient's ability for future childbearing. Or they end up in the intensive care unit with sepsis, which is the severe version of the infection that then results in adverse long-term outcomes to their mental health, their physical health, and then certainly the cost that then impacts families. So that's just one example of what our patients are seeing. It's one of the more common examples, and it's so common that across the nation, Society for Maternal Fetal Medicine was receiving requests from high-risk obstetricians to address this because they wanted guidance on how to handle the fact that in these restrictive states, they're seeing a lot more cases where the patients are not being offered the termination as management, and they're seeing more infections. But we can go to another example that has ethical implications, in that once you restrict access, it limits patients' options for childbearing. One patient, and again, this is, I talk about one patient, but there's multiple patients who've experienced this, who has had a previous child with a genetic condition. The child died after birth, and this is a condition that is known to be lethal within the first couple of years of life. this couple wanted to try again. And if we were talking about the time before restriction, they really had all options open to them. But after the restriction, they no longer had all the options, because if this is a condition where you could test for it either using chorionic villus sampling, which is a way of biopsying the placenta and getting the DNA analysis. The earliest you can do it falls outside of the range of these places that have either a total ban or a 6-week ban. So really, they would have no way of doing genetic testing. Their options would be to either undergo in vitro fertilization so that they can get very early DNA testing. And in vitro fertilization is very cost prohibitive for a lot of families. The other option is to really roll the dice and take their chances, knowing that that they had this autosomal recessive condition, and that with each pregnancy attempt, there was a 25% chance that their child would be affected, and that they would have a pregnancy that they would have to continue, knowing that it was lethal within the first 1 to 2 years of life. So two different examples, but in each case, you're seeing where the patient's treatment options completely restricted and have an impact on them, both short-term and long-term, has an impact on their health, has an impact on what their mental health will be, and certainly what their families look like in the future. But I will end it there. I just wanted to give those examples because I think when I see how people talk about the restrictions, they don't completely understand how wide-ranging the implications are and how severely they affect families out there and affect women and their choices.
Thank you, Dr. Louis. Thank you. That was really helpful to concretize this problem and show us what real patients and real clinicians are facing right now. I'm next going to introduce our second speaker, Professor Dov Fox. Professor Fox is the Herzog Research Professor of Law at the University of San Diego, where he founded and directs the Center for Health Law Policy and Bioethics. He's published more than 75 articles in leading journals of law, medicine, and public health, and has written extensively on the issues that we're talking about here today. One of the resources that we've posted through our webpage is an influential article he published last year in the Harvard Law Review entitled Medical Disobedience. And his latest book, Birth Rights and Wrongs: How Medicine and Technology Are Remaking Reproduction in the Law, was published by Oxford University Press. A recent award from the Robert Wood Johnson Foundation will support his research over the next 2 years on bridging ideological divides in domains of contested medical care, and this is certainly one of them. Welcome, Professor Fox.
Well, thanks to Professor Wolf for convening us at this critical moment, and to Dr. Louis for her extraordinary work. As she made clear, the situation in much of the country is bleak. Her state of Florida is one of 13 that makes providing an abortion a felony, punishable in some states by up to a life sentence, and with almost no exceptions. Not for the rape victims as young as 10 years old in Ohio, Mississippi, and Louisiana, who became mothers in grade school, one who gave birth clutching a teddy bear. Not for the cervical cancer survivor who had to drive 10 hours to New Mexico after learning that the baby boy she'd hoped to have was doomed by a fatal diagnosis. Not for the Texas woman who almost died after she was turned away for ending the dangerous pregnancy that left her condition too unstable to be able to travel out of state. Not for the patient in Georgia who did lose her life. Having arrived to a trauma center already septic, abortion care was declined for over 20 hours as she steadily deteriorated. Her white blood cell count rising far too high, her blood pressure falling perilously low until her organs began failing and ultimately her heart stopped. In cases like these, treating physicians and nurses might appeal to their heartfelt moral convictions, their conscience. Now, we're used to hearing about physicians or pharmacists who claim conscience to deny interventions that their employer or their profession or their government expects them to provide, but they deem sinful or wrong. Less familiar in our public discourse are professionals like the ones I just mentioned who have strong moral reasons for providing care to the people who come to them seeking it. These providers believe sincerely and profoundly that it is right to tend to patients and wrong not to. That, I want to suggest, is also a matter of conscience. The kind that just about every single state and another couple dozen federal laws protect absolutely, but only for clinicians who refuse care. Conscientious refusers enjoy immunity from whatever penalties they would otherwise normally face for violating professional standards in ways that predictably harm patients. For all the solicitude that conscience clauses afford to refusers, there's next to none for conscientious providers who are just as morally committed to providing evidence-based care. In fact, nowhere else in the world vindicates clinician conscience as this one-sided kind of trump card. Some countries don't offer any special dispensation to medical objectors at all. Other nations exempt conscientious refusers, but only under narrow circumstances from the expectations that clinicians would provide medically indicated care. Only in the US does claiming conscience mean that refusers, and refusers alone, can't be fired for violating their employment contract, can't be held liable for malpractice, can't have their license suspended for breaching informed consent, and can't be prosecuted for endangering their patients or abandoning them. It doesn't matter if conscientious refusers are the last physician in town. They don't even have to tell their patients what their medical options are. The only limits on clinicians' freedom to conscientiously deny care are the invidious discrimination prohibited by civil rights law on the basis of things like race and ethnicity, and urgent health crises in a hospital ER. When it comes to conscientious providers, though, it's unclear even whether the federal law that requires emergency treatment gives them any medical cover. This past summer, in a Supreme Court case, the majority declined to issue a substantive ruling on whether that federal law requires emergency care for abortion too, ordinarily, whether that would enable doctors to provide an abortion when continuing a pregnancy doesn't put a woman's life in danger, but still places her at risk of grave health consequences, the kind of abortion banned in some states. The kind of consequences, in turn, that might include, as Dr. Louise said, losing the chance for a safer pregnancy in order to have a wanted baby in the future. Most abortion bans have emergency exceptions in them, but they're narrow, and they don't specify how bad a harm must be to qualify, let alone how likely or imminent that harm has to be. They use open-ended phrases like substantial harm, permanent damage, things that give physicians no clarity about whether an individual patient who comes before them under particular time-sensitive circumstances would be able to get an abortion without risking the doctor's own medical license or freedom, their career or ability to support their family. These treating physicians are accordingly left to wonder, with a patient who comes before them and available treatment that could help preserve their health or save their life, whether it is criminally permissible for them to treat those patients. A couple of examples. What if, for example, a delay in abortion care would cause an unavoidable hysterectomy, as Dr. Louis said, that would keep someone from getting pregnant again? What if the timely cancer treatment that a patient needs wouldn't be compatible with continuing her pregnancy? How about if the complications from a patient's diabetes or her seizure disorder would risk blindness or brain damage if she's forced to continue that dangerous pregnancy? These laws don't say whether an abortion could be provided under circumstances like these without the provider risking prosecution. And as I mentioned, potentially decades in prison. This state of affairs helps to explain why abortion bans enacted since the fall of Roe v. Wade have been met by calls for civil disobedience. That is, to break the laws in order to symbolically send a message about their injustice. Within weeks after Roe fell in the summer of 2022, an editorial in the New England Journal of Medicine pressed doctors nationwide to defy criminal restrictions on providing abortion, accepting that the doctors who did so could lose their license and go to jail for up to 99 years in a state like Texas. I think this kind of sacrifice might be too much to expect of Dr. Louis and her colleagues, at least if a patient's life isn't on the line. Maybe morally admirable and righteous, but still too much to reliably depend on as a way to mitigate the worst harms that come from these restrictions on evidence-based care. Restrictions that come with deeply punitive criminal consequences. Nor do I think that a democratic regime ought to have to rely on people to be willing to go to jail and give up their livelihoods in order to meaningfully protest or save the lives of their fellow citizens. So here's another idea that I'd be grateful for a chance to engage with you all in the Q&A. It would be for federal lawmakers or state judges to adopt a partial legal defense to abortion ban prosecutions. It would say that doctors, out of respect for legitimately enacted democratic laws banning abortion, could still be prosecuted, still indeed be convicted for breaking those laws, could nonetheless affirm an incomplete defense that would reduce the penalties that they face. If those medical professionals can show that they've broken the law out of a deeply held moral commitment to provide care that falls within the medical norm. This, I suggest, would mirror the kinds of conscience protections that refusers get. Indeed, it would be eligible for refusers as well, and it would make more principled our overall conscience regime that governs the practice of medicine in this country. The idea would be that nor would conscientious refusers be able to have absolute immunity for, again, breaking even those criminal restrictions on endangering or abandoning patients. They too would face a conviction, but could have those penalties reduced by asserting a legitimate conscience defense under certain circumstances. But conscientious providers would also be able to assert this defense in modest and principled ways that would substantially mitigate the penalties that they otherwise face. Again, those decades in jail that otherwise leaves them hamstrung from being able to treat patients in desperate need of medical care. The idea of this kind of defense would be to respect the democratically enacted laws while vindicating clinician conscience for providers as well in principled ways that can individualize justice for the clinicians who claim conscience, refusers and providers alike. Well, my time is up, but I would love to answer any questions there might be about how this would be operationalized, how it would work, how it would fare against objections about the rule of law, the separation of powers, and so forth. Thanks so much for having me, and look forward to conversation with you all shortly.
Thank you, Professor Fox. Yes, I think we are going to debate that suggestion when we all convene. And I am seeing audience members posting questions, so that's terrific. Keep it coming, and remember, you can use the thumbs up icon to upvote questions that you agree should be high on the list. Our third and final panelist is Dr. Ann Drapkin-Lyerly. Dr. Lyerly is a professor of social medicine and research professor in OBGYN at the University of North Carolina, Chapel Hill, where she was also the first associate director for the Center for Bioethics. She previously served as chair of the American College of Obstetricians and Gynecologists Committee on Ethics. So that's the ACOG, Committee on Ethics, as many of us know it. Her research addresses socially and morally complex issues in reproductive medicine, including conscience in the provision of reproductive care, which Professor Fox was just talking about. Dr. Lyerly has published extensively on these issues, including co-authoring a very important article earlier this year in the Hastings Center report. Again, it's linked in our resources, entitled Beneath the Sword of Damocles, Moral Obligations of Physicians in a Post-Dobbs Landscape. Welcome, Dr. Lyerly.
So I want to begin by thanking you, Susan, for inviting me to participate in this important discussion, and thank the previous panelists for their very intriguing and important comments. So my comments today will draw heavily on the paper Susan mentioned that I published this year in the Hastings Center report with Ruth Faden and Michelle Mello, in which we consider the moral obligations of physicians post-Dobbs, particularly with respect for the law. So it came out of the fact, I guess, that I had noticed that amidst the important conversations about the harrowing impact of Dobbs, there seemed, at least a couple of years ago, to be a presumption that providers were bound by the law, not just legally, but morally, which didn't comport exactly with my understanding of how doctors maintained their integrity and protected their patients in the pre-Roe era. I think in particular of the doctors of a conscience that Carol Jaffe described in her remarkable book, and several of the older gynecologists I trained with who shared stories or made it clear in other ways that they found it ethically necessary to bend and sometimes break the law. So in what follows, I'm going to share our analysis of whether doctors now, post-Dobbs, might be morally permitted or obligated to do the same. So I'm going to begin by taking us back, though, to 2012, when the tragic death of a young woman following a miscarriage galvanized the Irish public into protests, eventually leading to the repeal of a 1983 law effectively banning all abortions in Ireland. The woman was named Savita Halappanavar, and in a case very much like the one that Dr. Louis was describing, at 17 weeks gestation, she presented to the hospital with ruptured membranes, signaling inevitable miscarriage. Doctors waited days until the fetal heartbeat stopped to end the pregnancy. It was a delay inconsistent with medical standards of care, but one her doctors believed the law required. It also cost Halappanavar her life. She developed sepsis and died. So in the inquiry that followed, Peter Boylan of the Irish Institute of Obstetricians and Gynecologists noted of practicing amidst restrictive abortion laws that the current situation is like the sword of Damocles hanging over us. If we do something with a good intention, but it turns out to be illegal, the consequences are extremely serious for medical practitioners. So for context, Damocles was a fabled courtier who, upon being invited to take the throne of a king, notices a sword above his head, dangling by a single horsehair, rendered in the image to the right. The story is an allegory for the hazards of power often, but also for the sense of foreboding that can accompany a precarious situation where a tragic outcome is restrained by a delicate trigger or chance. In Savita Halappanavar's Ireland, and now in the US, the hazards of pregnancy against a callous and capricious abortion law. As one practitioner put it, quoted in a qualitative study of abortion providers post-Dobbs, "I know what the right thing to do is for my patients, but I am carrying this legal worry and worried about what could happen to my family at the same time, and that's a terrible thing to feel." How, morally speaking, should doctors respond? Our paper addresses two questions. First, do the moral obligations that support providing clinically indicated care that is illegal because of abortion restrictions outweigh the obligation to obey the law? In other words, is breaking the law in these cases morally permissible? And two, are clinicians morally obligated to provide illegal abortion care where the life or health of the pregnant person hangs in the balance? So we address these questions against a typology of cases that we thought dramatically foregrounded the tensions that doctors face, although the breadth of possible cases is wider than what we attended to here. So first are cases in which pregnancy poses a threat to the life of the pregnant person. These include pre-viability rupture of membranes, the condition that took Savita Halappanavar's life, or something like primary pulmonary hypertension, in which pregnancy can be relatively uncomplicated, but the risk of death during delivery is up to 50%. Standard of care in these cases is to recommend termination of these pregnancies as early as possible. Second are cases that threaten the physical health of a pregnant person. For some women with advanced chronic disease, pregnancy can exacerbate the condition and leave them with lifelong disability. As Dobbs noted, blindness from diabetes, neurological impairment from epilepsy, spread of cancer where pregnancy would require treatment delay. There are many other examples. And third, cases that threaten the mental health of patients, arguably inclusive of any coerced gestation, but particularly stark in pregnancies resulting from rape or incest, or in cases where women are forced to carry a pregnancy complicated by a lethal fetal anomaly. We also considered loss of fertility, but in all the cases that we could consider, those cases also threaten the life or the physical health of the pregnant person, so we folded them into our analysis in that way. So as we have heard in all states, there are exceptions for life. When we started this paper, 3 states did not have exceptions for the life of the mother. In most, but not all, for the health of the mother, and in many, exceptions for rape, incest, and fetal anomalies. Yet all too often, exceptions offer an empty promise. There are 4 reasons that we sort of parsed out, but you've heard about some of these today. One is the law is ambiguous. What does life-threatening mean? What is a substantial physical impairment? 2, the requirement for urgency. Many laws require or are interpreted to require that a woman be in imminent peril. This results in delays in care and precludes abortion for conditions in which death is likely, but in the future, like primary pulmonary hypertension. 3, for mental health related conditions, rape can be difficult and traumatic to prove. The presence of a fetal heartbeat is often misinterpreted as a reason not to terminate a pregnancy that is destined to die. And as a cruel amendment to exceptions, many states explicitly exclude mental health, including threats of self-harm, as life-threatening conditions. Finally, we know that where there is legal uncertainty, doctors and the institutions that support them tend to over-comply with the law, understandably, but this has been shown in a number of studies. So another quote from the Sabbath article that I think portrays the situation quite dramatically. The way our legal teams interpreted it until they became septic or started hemorrhaging, we couldn't proceed. Is 5% risk of death enough? Does it take 20%? Does it take 50%? What is enough legally? It just feels horrible to say that you're at greater risk, you're at a greater than likely chance of dying, that until you're at a greater than likely chance of dying, you can't make a decision. So knowing a patient is sick and then waiting until she is severely ill or on the brink of death is not how we practice medicine in any other context. It feels horrible because it is inconsistent with the ethical practice of medicine. Clearly, being caught between the law and ethical care of patients is the reality. So how should doctors respond? So again, we go to the first question: is breaking the law morally permissible? So it's generally agreed that there's a moral obligation to follow the law, and it is also generally agreed that there is no obligation to follow the law where it is unjust. Most would agree that forced gestation laws are unjust, but there are 3 additional arguments that we considered that don't require making that case. They include to protect conscience, to abide by professional obligations, and as a means to change the law through civil disobedience. And we'll all consider these one at a time, briefly. So as Dobbs has argued eloquently in his paper and today, conscience-based refusals have received strong support, often grounded in the right to moral integrity. Conflicts of conscience in reproductive medicine invite, I think, 2 kinds of refusals. The first is the very familiar refusal to provide care. So when I chaired the ACOG Committee on Ethics, we issued an opinion to address reports that patients were experiencing refusals of care based on physician conscience. We issued a statement making the case that while conscience protections are important, they should be limited, considered against obligations to respect patient autonomy and protect patient health. This document, I want to tell you, and this is not necessarily public knowledge, met with huge pushback from a vocal minority of OBGYNs, some leadership at the organization, as well as a slate of US senators who said that conscience should rule. As an aside, the committee has since reaffirmed the document and it still stands. But there is another kind of refusal, and so my formulation is a little bit different than Dobbs. Refusal to obey the law, particularly a law that requires a doctor to withhold care that would protect a patient's life. Refusing to follow a law that would leave you with blood on your hands for the rest of your life is absolutely consistent with the kind of situation that animates such strong support for conscientious protections. And so if we put these side by side, it's quite obvious to see which offers a stronger case. Refusals to provide care oppose patient autonomy and interest. Refusals to follow the law support patient autonomy and interests. Refusals to provide care deviate from standard practice. Refusals to follow the law align with standard practice. And finally, refusals to provide care have negative consequences for patients. And unfortunately, as has been made clear in this seminar so far, refusals to follow the law have negative consequences for doctors. So I think that all is to say that conscientious maintenance of moral integrity, maintenance of one's conscience is a grounds for permitting a person to break the law. Doesn't require it, but it permits them to break the law. So the second reason that breaking the law is morally permissible regards professional obligations. So we know that physicians have a fiduciary duty to prioritize patient best interests. State bans often restrict care, even care normally provided by those who actually who oppose abortions. So following the law may violate the duty of non-maleficence. So around the time of Dobbs, a report out of UCSF in Texas cataloged more than 50 deviations from standard of care for women that were harmful or dangerous. And in many cases, such refusals would, at least pre-Dobbs, be strong grounds for professional sanction or malpractice. So the third justification, and Dov touched on this quite eloquently before me, would be to serve as a means to change the law through professional civil disobedience. Civil disobedience has been defined quite eloquently, I think, by Jim Childress as a public breach of law undertaken with the aim of bringing about change in laws or government policies. And there was this very provocative piece by Matt Winia in the New England Journal of Medicine, urging consideration of professional civil disobedience among doctors. I do think it is important to note that civil disobedience is different from conscientious refusal in at least 3 ways. Civil disobedience is a public-facing act, whereas conscientious refusal is a private act. Civil disobedience is communicative, a form of speech, where conscientious refusals are usually personal and they protect a person's integrity, an individual person's integrity, and civil disobedience accepts or invites legal consequences. So the move to be protected from legal consequences is really toward conscientious refusal. So again, certainly not a moral obligation, but courageous and worthy of praise. So there are strong arguments that support physicians breaking the law if they choose to. In other words, it's morally permissible. The question remains, though, whether breaking the law is ever required. Martin Luther King might say yes. He said in his letter from the Birmingham jail, one has not only a legal but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. So this was, whether there is an obligation to break the law was a more difficult question for us, though. And we concluded eventually that there was a circumscribed duty to treat. Part of the reason it was so difficult, I think, is obvious from what we've discussed, which is that doctors in their public testimonies and expressions, and what we have learned from the law, is that there are serious consequences of disobeying post-Dobbs laws. These have included civil and criminal penalties up to life in prison, loss of job, licensure, and harm to families. So we got some guidance from a 1991 paper on the duty to treat in the context of HIV written by bioethicist Norm Daniels. He argued that doctors have a limited duty to treat where the risks of providing care exceed what might reasonably have been anticipated when they entered the practice of medicine. So when risks exceed the standard level, as they have most certainly in many states, provision of care may be beyond the call of duty. But we offer 2 exceptions in our paper. The first is that the law does not supersede a physician's duty not to abandon their patient. So that when a threat is urgent but not time sensitive, physicians still do have a moral obligation to refer to a doctor who is willing to risk legal sanction or practices in a jurisdiction where abortion for that indication is legal. Second, if a physician has the means to prevent death or life-threatening harm to a patient, their duty to provide care remains. When such a threat is urgent and time sensitive, a woman is hemorrhaging, for example, the doctor has a moral obligation to intervene to save her life. Needless to say, physicians should not be left out to dry. Institutions have moral obligations as well, including refraining from self-protective action that increases physicians' burdens. This would range from poor communication to standing up so-called ethics committees, and I definitely take issue with that term, to authorize abortion that are already medically indicated and ethical. And second, providing a basic suite of supports, such as speaking publicly in support of physicians, providing abortions, paying legal fees, resisting investigative efforts, security measures, and for the boards, refusing professional sanction. So in conclusion, despite the protests of lawyers and architects of the post-Dobbs landscape, it is clear that state laws following Dobbs have created barriers to life-saving and life-preserving care for pregnant people. Breaking such laws may be morally permissible on the basis of conscience, professional obligations, and civil disobedience. Breaking the law is morally required where there is a serious threat to life, either by referral or provision of care in time-sensitive situations. And institutions have an affirmative duty to support physicians and other providers of reproductive health care. And thank you. This is a image from the New Yorker that I find very apropos to our current situation.
Wonderful. Thanks to all three of you. And thanks to the audience, because we've got some great questions. Keep them coming. So we're now going to go into gallery view so we can all talk together. And I am going to start with the most upvoted question. I'm looking at the QA. And I'd like to start with Dr. Louis with this question. What can physicians do as a group to advocate for patients and our profession? The questioner says it is unconscionable that politicians are not only restricting the autonomy of women, but also dictating how we practice medicine. And there are a few other questions in the queue, basically saying, why is this all falling on individual physicians? Where are the medical professional societies? As Dr. Lyerly just argued, where are the institutions? Why aren't they standing up for their doctors? And why aren't the medical boards saying, forget it? We're not going to strip licenses for physicians practicing standard of care. So what's going on? The most vulnerable person in this picture, aside from the patient, is the single physician.
Yeah. It's not as easy as it sounds, right? All of those things you said in theory would happen. I can tell you that our organizations are trying, but in reality, even if you take the field of obstetrics and gynecology, we don't think, uniformly as a block, right? There are pro-lifers organizations within obstetrics and gynecology also. So you have to take that into account too. And that while it is true that within subspecialties of OB-GYN that you may find some subspecialties lean more heavily in terms of their beliefs in restriction, the reality is, humans are complex. So that's number one. Number two, our organizations are trying to help. And so the example I can give is my Society for Maternal Fetal Medicine, that we are trying to provide the tools to support the physicians in their decision making, to say, hey, these are the guidelines for clinical care, so that they have something to back them up. The reality is that regardless of what anybody does, American Board of Obstetrics and Gynecology could say, we're not going to strip your license. But the reality is, if I, as a physician, get accused of violating the law, that even before we get to my license, there are so many other ways that it impacts me, because now I have to defend myself. Medical malpractice doesn't cover that, because now that's, a felonious charge. My family is affected. Financially, I'm affected. My work is disrupted. My mental health is disrupted. And so even if at the end of all of that, I'm vindicated, I will have paid a personal cost, a substantial personal cost. So yes, we're not alone in that there are people trying to help us, but the reality is what I just described. And for the few, healthcare people who have been on the side of that, they will tell you they've paid a tremendous personal cost. The other piece as to what we can do, I think keep advocating through our societies. But the reality is we also have to advocate with our patients and our family members. There's so much misinformation out there. When you have people saying, I have never seen anybody's life in danger from pregnancy, that's a harmful statement. But then when you qualify who's making that statement, these are people who wouldn't be in a position to see it. Or there are people, right, either, healthcare professional or not, there was an obstetrician who said it, but this is not an obstetrician who takes care of pregnancy, and certainly they're taking care of it during a time when, in pre-Dobbs. So there are false statements, but people hold on to those statements. So I think, what we can do in part is making sure that everyone is educated with the truth so they truly understand, and then keep advocating through our societies. I'll defer to others too.
Well, some of what you said, I want to sort of add on to the question and then go to Professor Fox. Because with your description, Dr. Louis, of the reality, even if there was a sort of mass protest, what it would be for an individual physician to be accused of a felony, to have to mount a defense, to have to pay for a defense, to have to, for their mental health, for their ability to practice, for their family. It raises a question, I think, Professor Fox, about your proposal, whether in fact, creating an affirmative defense that the accused physician would need to prove in order to get a reduction of penalty really doesn't remove the sword of Damocles.
I think that there are things that groups and organizations are doing. There's more that they could do, and it wouldn't at any rate be enough. Just to briefly pile on to what Dr. Louise shared from her experience. Some have encouraged the deans and department chairs, for example, at academic medical centers, to continue providing full reproductive care like abortion, regardless of the state laws. Others have urged state medical boards and national professional associations not to demote or suspend or otherwise penalize civil disobedience, who would otherwise be penalizable in that way. Instead, to support them if they break the law to provide evidence-based care, support them in ways, for example, by declining to cooperate with police and prosecutors who would go after them, by subsidizing their legal defense, by underwriting their attorney's fees, by testifying on their behalves. I think these are all good starts and measures worth adopting. But even if supportive employers or medical boards or professional associations enact these measures to help folks like Dr. Louis, the civil and criminal consequences of violating state bans on abortion care will nevertheless just be crushing. Hundreds and hundreds of thousands of dollars in some states. It's every time anyone, anywhere brings a suit against you. Life sentences in jail, permanently losing your medical license. It's just too much, I think, to expect, let alone demand. At least if you're not facing a patient who would otherwise die, which is why I think highly imperfect, but I think a worthwhile alternative would be one that would be, I guess, a compromise measure of sorts, one that tries to recognize a more principled approach to conscience for the reasons that Dr. Lyerly raised. It would be to say that doctors could still be prosecuted, could still be convicted, could still be taken to court, which is obviously an enormous cost they would endure, a price to pay, but that the penalties would be dramatically reduced by way of claiming this conscience defense that I think they ought to have. And I think there are ways to make this happen, even in states that ban abortion and that would not want to see such a defense over state lawmakers. It would, in other words, for example, say take a $100,000 penalty and reduce it down to 5 or 10. A life sentence in jail, maybe 1 to 3 years, a permanent revocation of someone's license to practice medicine in the state would be a temporary suspension instead. This is not going to be enough, maybe, to get everyone to express conscience. It's still an enormous cost, but that's not actually the main point or purpose of the proposal. As much as I would like to see that, it's rather to protect conscience in more principled ways in recognition of this background regime that Dr. Lyerly raised. You know, when Roe was first decided, more than 50 years ago, the very first law that was passed, the same year, in fact, out of Congress, was a more principled conscience regime. It protected conscience for refusers in very limited ways that have kind of no longer especially relevant for some pedantic, legalistic sort of reasons. But it said conscientious refusers couldn't be fired or discriminated against, but conscientious providers couldn't either. If a Catholic institution wanted to fire someone for providing care, that there were limits on how they could do that and protections for those providers. It's just been this creep of conscience that has become extraordinarily lopsided in the decades since, to the point where now we know of conscience only as something for religious refusers and not for providers or to secular physicians. And I think that's a mistake, and one that we can and should correct. And I think it would certainly be no panacea for the kinds of problems we've discussed, but I think it would help.
Dr. Lyerly, I wonder how you think about the proposal that law could keep the prosecutions in place, honor the laws, but create a regime of potentially reduced penalties if the physician could shoulder the burden of proving conscience, proving an affirmative defense. It sounds like a way of trying to balance two things, which is what has the state legislature chosen to do? What has the democratically elected legislature put in place? But at the same time, recognizing that physicians not only have personal conscience, but they're members of a profession. And the profession has ethical commitments. How do you think about that?
Well, I was going to sort of respond to Dobbs' proposal and offer that sort of the pragmatist in me thinks, any port in a storm, any way that we could, reduce the challenges faced by physicians is worth considering. On the other hand, the principled part of me says, no way. With all due respect, when I first started working on conscience, one of my favorite papers was one written by Altacharo, which was criticizing this notion of conscience without consequence, right? So that people could be protected in their conscientious refusals across the board and not have any consequence for themselves, right? In medicine, they don't have to move to a different state. They don't have to declare that they have a moral view that's going to preclude them from offering the full range of services. They don't even have to talk about why their conscience compels them to do these things, and yet they have a monopoly over this care, right? Which seemed very wrong to Alta and to me as well. But when we're talking about conscientious refusal to obey the law, it's, conscience with a massive amount of consequence built into it. And we're talking about reducing it a little bit. And if you remember my slide that compares those two things, the moral case for conscientious refusal of the law, when we think about all the things that undergird the ethical practice of medicine, the case for conscientious refusals of the law is much, much stronger, right? And yet that is the case that we are saying, oh, you have to prove that this is a matter of conscience. The other thing that I would share about this is that when ACOG published their guidance about conscientious refusals, one of the things that we did is that we sort of tried to give a foundation for why we protect these kinds of actions, right? And the writers of that document landed on the moral integrity formulation, right? That if you do something that opposes your conscience, you will in the days and weeks and years that remain, not be able to sleep at night, not be able to live with yourself, feel terrible, be morally traumatized, right? And so we want to protect doctors as much as possible from experiencing that, right? It seems like the right thing to do, doctors or anybody for that matter. And that formulation of moral integrity was one of the things that those who opposed the limits of conscientious refusal attacked, because they wanted to formulate their ideas about conscience on whatever grounds that they needed, whether it was just a religious belief, whether it was personal preference, or a range of things, rather than a coherent formulation of moral integrity. And so I think, again, to say that those who are acting in accordance with their conscience to protect their patients, to protect their moral integrity, in providing the law, that are willing to take a risk, have to prove to a judge and jury that they were actually acting from conscience, when those who refuse to provide care don't have to do any of that. So I am just somewhat skeptical of moving this sort of private sphere of decision making into this public space, which is not a safe one for many, many reasons. And I mean, we could talk more about affirmative defenses and reasons why they have not been workable. But I think, those are the two things that came up for me that make me, from a principled standpoint, somewhat worried if, without, trying not to throw out the baby with the bathwater.
If I could reply very briefly, in your scholarship, in your presentation, you've crystallized the stakes so beautifully, and I think radically redrawn the asymmetry in the law and shown how it really is so out of sync with the moral stakes in question. I think we share most of our commitments, and yet adopt a very different approach. I hear you that conscience carve-outs strike you, I think, quite reasonably as the wrong response to a very bad law. These treatment bans are fundamentally flawed. And so it's easy to see how just tinkering around the periphery isn't enough in ways that leave these profound costs on good faith doctors doing God's work to still face these terrible consequences and put them in this impossible condition beneath the sword of Damocles. How watering down a pernicious restriction might even make it harder to dislodge if it leaves the people who it harms less motivated to mobilize for more structural or lasting kind of reforms, the more principled ones that you advocate. If they don't have enough as much reason to persuade others that the underlying ban itself is worth uprooting. I think the pragmatist in me, looking back on our history of legal reform in this area, given how deeply polarized we are, thinks that meaningful transformation to repeal a law or regime or replace it tends to happen very rarely and slowly at best. And that even the most inspired activism and the most effective campaigns, face stubborn entrenchment and other, kinds of political obstacles. And that getting from that aspiration that I think you and I both share to, operationalize it is a very long and uncertain road. And that outside chance I see of this kind of reform at some point down the line is just of no use to beleaguered providers and their patients who are desperate for care in the here and now. And so I offer this middle ground compromise as a way to try and get us from here to there in ways that I hope will not water down the push for the more principled and fulsome approach that you have so persuasively argued for.
I think you're all showing how tight the grip is of this conflict between law, ethics, and medicine. I'd like to go back to you, Dr. Louis, and ask you a question that I'm seeing a number of our audience members ask, which is about training, which is how are you and your colleagues training medical students and residents and fellows and junior attendings? You read in the news that some physicians who can are voting with their feet and not going to states if they have an option, or leaving states that have them in the grip of these threats. And so I'm wondering, and our audience is wondering about trainees, what they're going through and what you're seeing.
Yes, there's clear data that during the application season, when medical students are applying for residencies, that in states where abortion is restricted, there's a reduction in the number of individuals who are applying to those programs. And so it does create this problem where now you have a certain percentage of the training programs that will not have good training in the procedure. And those individuals then go on to become full-on attendings. And so over time, what you will see is that there will be fewer and fewer obstetricians with the skill set to do the procedure. Now you pair that with already the physician shortage, right? So then what you're going to find is that there's even further restriction to access, because not only will there be a physician shortage, but then the ones who are in the workforce, a lot fewer of them will have the skill set. Because they weren't even trained in it. And we do know there's a huge drop off in between training and practicing. So during training, even if they're trained in performing abortions, a certain percentage will stop performing them because they don't have for a number of reasons, either preference or they don't have access to the right setting for them to be able to do it, or they're in practices that don't support it, et cetera. So bottom line is that we are setting up this whole setup means really a lot of peril for women in the future because they just won't have access. But I also try to make sure that patients understand that these laws are impacting their access to general OB-GYN care because fewer OB-GYNs want to practice in this setting. So what we saw was a number of people stopping from doing obstetrics at all, and they now just do gynecology. And also we're finding that it's harder to recruit people to come to this state to practice. Particularly if being able to provide that service is important to them, or if they're concerned that they will be in a scenario where a patient will require it and they will not be able to do it, then it's dissuading them from actually taking these positions.
So then one other piece of the puzzle, if you're talking about exodus of physicians or early career physicians avoiding residencies in states that have these restrictions. We also have people in the audience asking about parts of the country, parts of, all of our states where sectarian hospitals, Catholic hospitals, and hospitals with religious commitments may be the hospital, may be how people get their care. And it would be helpful to hear from, well, you have a national view, but also Florida. Are we looking at obstetrical deserts where people just really can't get abortion care, even if they need it on pain of their life?
Some of these hospitals have signs out front asking the public to vote no on these abortion measures, right? So for sure, the patients do not have access. And then that's where you face an equity problem. So those who have money or have resources will say, I'll just fly to, insert state with without restrictions. And then there are organizations that are helping those individuals to help fund it for individuals who cannot, who don't have the resources. But there are large groups of people who just don't have access because the local hospital is a religious entity that even within the confines of the law, they will not provide that service. And that has been a long-standing problem even before the Dobbs decision. But in recent years, more small hospitals are closing. And so there's more maternity care deserts. So the Dobbs decision and all of these restrictive laws in the context of the environment with fewer places to get obstetric care is worsening that problem where patients just do not have access to it unless they have their own personal resources.
It's a great question. I wonder why this is something that Dr. Lyerly and I can agree on. I think Dr. Louis has really helpfully painted the portrait for us, where increasingly very, very large healthcare conglomerates are under the religious directives that forbid abortion. Again, even in states that still permit that care. Dr. Lyerly mentioned that doctors, to get these protections for conscientious refusal, don't even have to tell patients that, say, an abortion would be the medically indicated kind of care. Well, one thing we didn't get to talk about is that these conscience clauses protects institutions all the same, and it doesn't matter whether those institutions control the healthcare market in broad swaths of the country to the point where, as Dr. Louis mentioned, there is just no other option for patients who live within, say, 30 miles or half an hour and need that care. Here's where I wonder whether we might agree, is that in whatever changes we make to our conscience regime in ways that might be able to make the situation better, it is just a fundamental misunderstanding of the concept of conscience to think that institutions can and should enjoy its protections. Institutions are important things, and they can have all kinds of interests in facilitating expression, associational interests. I don't think that conscience is one of the interests that they have. And so it's just a mistake, a category mistake, a legal mistake, a moral mistake to give protections not only to individual clinicians, but in these massive conglomerate entities that have increasing controls over whole healthcare markets to refuse care in ways that have even much greater effects than protecting individuals. But I'll leave it to Dr. Lyerly to see what she thinks.
Well, first of all, Dov, I think we agree about a lot of things. But when it comes to religiously funded hospitals, I think there's some important work that's been done that showed that in the era of Roe, part of the reason that those entities could operate was because providers in those entities who may not have shared the sort of conscience that the institution has always had the option of, or not always, but often had the option of referring their patients who were in dire straits to a local hospital that was available to provide care. And as those institutions may be in states that are highly restricted, or maybe in a situation where such care is not available from a local hospital, then actually it becomes a much more complicated situation for anybody working in one of those hospitals. So they made it before, but now it is extremely morally complicated for them. And I think pushes us toward the question, and people have asked me, why did we focus on these sort of dire straits cases when their coerced gestation for a variety of reasons is morally problematic, right? And so I think that the important thing to note is that now there's really no sort of safety valve for either doctors or women, right? As the red swath grows across the country of restrictive states. So I think that the pressure is now increasingly on where it was uncomfortable before, and pushes us toward the question of moral responsibility of doctors and institutions to provide abortions that may not have felt that responsibility before. I mean, the example I often give is that many of my residency mates did not provide abortion when they got out into practice in Raleigh or in surrounding areas because they knew their patients could always get an abortion if they referred them to somebody else. Now, I would say, even with the law up against them, the moral pressure to provide more comprehensive care is actually higher, right? So, it doesn't make this any easier, but I think we have created we haven't created, but a very dire situation has been created for, all involved, those who have moral objections to abortion, those who provide maternity care, and those who are consumers of it.
We're coming to the end of our time. I wish we had a lot more time, and we have great questions. I want to squeeze in one more quickly. And I might turn to you, Professor Fox, and ask you, echoing some of the questions, but also a little bit lawyer to lawyer, can't lawyers and the law do a better job? Can't we help? I mean, couple thoughts. The news has reported that Amber Thurman's family in Georgia has now brought suit for her death against the hospital in Georgia, where she was not provided timely care. So it's possible that wrongful death suits and the like will come down the pike and serve as a counterbalance. As you noted, this federal law, EMTALA, it's still not resolved by the Supreme Court whether it preempts some of these state restrictions in emergency departments, particularly for life-threatening emergencies. Um, uh, and part of what Dr. Louis is describing is one of these cases erupts, and sure enough, the institution's lawyers are in play. And they have a fork in the road, right? They can either say, no, 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 nobody can do this, or they can say, wait a second, let's work together because we've got a patient who could die. Can law do a better job?
Um, I, I, I'm not hopeful. Um, the legal representatives within hospital institutions are deeply conservative. They don't want to bring prosecutors um, into the hospital. Accordingly, I'm not optimistic that they're going to advise their clinicians, the employees who work there, to push the limits, to say, hey, we think that hopefully maybe it looks like you probably have legal cover. No, they're going to say we don't want we don't want the state prosecutors in our hospital. So we're going to advise you to adopt a more defensive or conservative approach. That's certainly what we've been seeing so far. As for laws that mandate care as opposed to forbid it, you're right. Right now, we've got a a legal regime that is contradictory at best. There is a double bind that physicians are in these emergency circumstances. On the one hand, the state abortion ban says no abortion on pain of very serious criminal penalties. In emergency cases, on the other hand, there's a federal law requiring emergency treatment in ERs, and also state laws that say it constitutes malpractice to fail to live up to your standard of care, wrongful death if that kind of negligence results in someone dying. That contradiction arises from a contradiction in how our society and legal system regards abortion care today. What was until 2 years ago regarded as Dr. Louise said, healthcare as as essential matter of medical treatment was unceremoniously, all at once, sweepingly, after these trigger bans came into effect after the fall of Roe v. Wade, just redefined from healthcare to a crime. And so this unanswered question that seems like we probably have not so good answers implicit or lurking or coming down the pike are to suggest that these existing vestigial requirements of providing what we've regarded as healthcare would no longer apply, or may not, because it was healthcare, but now it's a crime, and there can't be an obligation to perform a crime. And we are right now in this battle over the very definition of what abortion care is. And until we resolve that, it's hard for me to see how clever lawyers might be able to navigate this redefinition. How, in other words, do you argue that you should allow for just a little bit of a crime? What's even in many states regarded as something tantamount to homicide or murder? It makes it very hard, but we'll see how things play out. And I think the litigation, Professor Wolf, that you mentioned, wrongful death, malpractice, is a very worthwhile place to start. We'll see how it plays out. Again, I wish I were more optimistic than I am.
Well, I want to thank all three of you for so beautifully laying out this excruciating problem and beginning to debate with each other where we go from here. I also want to thank the audience for great questions. I wish we had much more time. We will be sending everyone an evaluation shortly after we close, so we'd love your feedback. Remember that we're going to be posting the unedited video of this basically right away on our YouTube channel and website, so feel free to share, use it in any way that you'd like. And stay tuned because we will be having more in this series on when law, ethics, and medicine collide. Thank you all.